Hi, I'm Susie Paulson, and I have Monica Coleman here with me, and we're both attorneys at OMAG with significant experience in labor and employment law. And so, when asked to do this presentation, and it had to be 3 hours long, I thought of this boot camp that I've done in the past, and I thought this would be a good opportunity to work through this workbook and help you as clerks, if you're ever faced with the situation where the city gets a complaint and there might need to be an investigation done. So I put together this workbook. I hope everybody got one in the mail. If you didn't, you can go to our website and there's a PDF document that you can either follow along or print. It has some places on there for you to make notes. So hopefully you can make notes on that. But we're going to talk about everything from, when an investigation is initiated to the scope and all the way through writing the report. And at the end, Monica and I will work through some case studies that can kind of help put that into action for you so you can see how the process actually works. So again, take notes in your workbook. There's also some sample letters and notices in the back, pages 54 through 63. So let's start. Monica, again, is going to help me work through this workbook. Between us, we have a lot of experience. We've done these investigations, so I'm hoping that we can add more than what's actually in the workbook and the bullets. And then if you have questions about that, again, email us or call us and let me know. So Monica, let's start with page 4. That's the initiation of a complaint or potential investigation. Now, I will say not every complaint is going to lead to a full-blown investigation. Some are going to be pretty open and shut. You get a complaint that an employee sent an inappropriate email. You're going to know who sent the email, who it went to, when it went to them. Hopefully you'll have experience with that employee so you know if they have a history of doing something like that. So that might be an open and shut investigation where you wouldn't need to go through this full process. So this is really a process when the city is given a written complaint or a verbal complaint, typically about the discrimination and harassment policy. And one thing to make clear, and I'll let Monica elaborate on this, what's being investigated. So it's the policy, not the law, that's being investigated.
That's correct. That is critical to bear that in mind throughout the process, because I think a lot of times what we see is you likely will have a combination of issues, and sometimes a sexual harassment complaint can turn into something that's more than a policy violation. But as investigators, you must limit yourself to only investigating those issues that fall under the policy. If there's anything that falls outside the policy, say something criminal, that should not be part of. Note that in your investigation as you're working through it, but that should be referred over to the police department or something like that. And I think we'll talk more about that in a moment. But that's why it's so important to have your policy in front of you and know the limits of your authority to conduct this personnel investigation fall under that policy.
Okay. So I just wanted to preface this with that we're talking about investigation of violations of potential city policies, not the law. So we're not necessarily going to talk about the law here. Again, like Monica said, it could lead to a civil lawsuit and in some instances, criminal allegations. But, generally speaking, we're talking about investigations of policies. Hopefully your city has a policy. If not, we have sample policy on the website as well. So let's start with page 4. And we're going to talk about the initiation of a investigation. So meaning, how did the city find out about the complaint? Was it written? Was it verbal? What are your thoughts on that, Monica?
Yeah, so as you have listed here, I think in my experience, most of the time, something has been provided in writing. But if in your city you have an anonymous tip line, we had that in Oklahoma City, that's anonymous. People can call in and make all kinds of allegations on that line. They don't have to identify themselves. So that's a common method of reporting as well. But really, employees can, in roundabout ways, report potential policy violations in ways other than a formal complaint. So it could be just in workplace documents, emails, word of mouth. They may tell a friend who tells a friend who tells a friend, kind of thing. So you just have to accept it in whatever form it presents itself and then work through it from there.
Okay. And on occasion, there's an incident where maybe the person just witnessed someone else being bullied or harassed in their opinion.
Good point.
And so they're complaining on behalf of the person that's being harassed. It doesn't have to be the actual person that's being harassed. In that instance, obviously, the first person you would go to is this person that they're complaining on behalf of and ask them how they feel about the situation. You would obviously document that. Let's see. One of the things in here in the workbook talks about performance evaluations. Or a lot of times if an employee is being disciplined and they're allowed to write comments on their discipline. I've seen it in that regard. I've seen it in grievance documents. So if you're in a city that has a grievance process or an appeal process for discipline, sometimes they may make a little, note in that document that says, well, I wasn't performing up to my standards because I'm continuously harassed by coworkers or a supervisor, etc. So all those things you should take seriously. Again, what type of investigation, how in-depth of an investigation is going to deter, we don't know what that is necessarily. We'll talk about that. That's a good segue into the scope of the investigation.
Yeah, I have one thought though, before we move into defining the scope. When you do receive a complaint that falls under your discrimination and harassment policy, or appears to, allegedly does, all of those caveats, make sure that if there is potential workplace conflict, you've got two employees who are, one employee's complaining about another employee. It's a good rule of thumb to make sure that you have addressed any of those potential conflicts at the outset before you proceed into the investigation. It may be that you need to put them on different shifts. You may have to send one home for a period of time. I mean, those are all issues to think about. You don't want this festering conflict kind of relationship present while you're trying to work through the issues. So I just kind of throw that out there, that may be something that needs to be addressed at the outset before you get started.
Yeah, because you definitely don't want them working together when you're pulling people in and doing interviews and talking to them.
Right.
So
And
temporary in nature typically. But
right, and ensure, to the extent possible, ensure that your complaining party understands that you will maintain confidentiality to the extent that you can, but that it's not 100% confidential, because there are people who are going to have a need to know what you're investigating. So that just two little points that we can talk about as we work through this, but I thought worth throwing out at this point.
Okay, so let's move on to the scope. That's on page 6. So when I'm talking about the scope of the investigation, I mean, there's some bullet points here, but if you're the investigator, you need to know what the scope is. And if you're not the investigator, but you're going to hire, say, an outside person to do the investigation, they need to know what the scope is. And when I say scope, I mean, what are they investigating? Who are they investigating? Is it strictly those things that are being investigated? Are they allowed to kind of, I don't know, Monica and I call them chase rabbits a little bit. To what extent can they chase rabbits? Meaning you'll get in an interview with someone and you're talking about one specific issue and they say, well, while we're in here, there's also this issue. So as the investigator, you need to know, are you allowed to kind of go down that road or do you need to pull it back in? Obviously, you'll make notes about that in your investigator notes. May not make it to the report, but if you have questions and you're not the person that gets to decide the scope, then obviously you're going to have to go to the city manager, the mayor, the city attorney, someone higher than you that's kind of directing it and will ultimately be the decider as to whether there's a policy violation and what's going to happen as a result of that policy violation. So as the investigator, you want to have full knowledge of what you're investigating. Are there some other things on here? Let's see. What policies are you investigating? As we said at the start of this, you're investigating policy violations, any directives, any ordinances. What else, Monica, can you say?
Period of time. As Susie said, you may have a report of an incident that is alleged to be a policy violation, and that would be your the obvious issue that you're going to investigate. But so many times, and that occurred on one day, but so many times we see the issues mushroom into so many more, which could then expand the period of time that you're looking at, and it may be that you have to initiate separate investigations into separate issues. But I would say the period of time that you're investigating has to relate right back to the issue that's been reported, and I mean, that can range to an isolated day to a period of time, depending on what the issues are.
Yeah, I mean, it could be one email.
Sure.
Or it could be, kind of a toxic environment,
right,
or supervisor that's festered over time.
Right.
Yeah.
Right.
So obviously, as the investigator, you need to know what's the time frame that you have to do this in, because that may dictate part of what your scope is. If you only have 2 weeks from beginning to end to get the investigation done, and you have potentially 25 people to interview, that's going to probably dictate who you interview first and what kind of questions you ask and what issues you focus in on.
And I think be prepared to give yourself a little bit of grace on that point, because we want to be as swift as possible in conducting the investigation and getting it completed so that action, if necessary, can be taken as quickly as possible. But depending on how the investigation goes, you may need to expand the amount of time that you have, because there may be other witnesses revealed that you need to talk to that you didn't anticipate in the beginning. So I think it's good, as you're formulating your investigation plan, to kind of have that target, but just be prepared to, give yourself a little bit more time if you need to, in order to be complete in your investigation. Don't rush through it so that you leave important things untouched.
Yeah, and to that point, if you do have officials saying, I need this done in 2 weeks, I think you just say, I'll do the best that I can.
Yeah.
A lot of times what happens, it's the city clerk doing the investigation. So you have a full-time job on top of this very time-consuming investigation sometimes not. A lot of times it is, though.
I mean, you may have a key witness who has become unavailable for various and sundry reasons. You don't want to wrap up an investigation without having interviewed a key witness. That's critical to your evidence in your investigation. So there may be things that happen that are beyond your control. So have your plan, have your target date. All of those things are prudent to do, but just know that inevitably things are going to happen that cause you to have to be a little bit more flexible than you may want to be.
Yeah, and I would say document those things. So, I know we're talking about policy violations that you're investigating, but we're doing an investigation, one, because it's the right thing to do and we need to find out if there's, people in the workplace who are violating policy. But two, the law says if there's a complaint, the employer has to do a prompt, unbiased investigation and take remedial action if it's warranted.
Right.
So if you can't take prompt action, then you need to document why. Mm-hmm. So say you're one of the main people you need to talk to gets deployed for 2 months.
Yeah.
Right? So you want to take prompt remedial action, but the main person you need to talk to is not in the country for 2 months. So just make sure you keep a timeline of the witnesses, or for some reason you can't do any interviews for 1 or 2 weeks because you're going to be away at a conference, or it's budget season. Just document some of those things. So if you do end up in the litigation process and they want to argue this investigation took forever, it wasn't prompt, it didn't meet the guidelines of the case law and the federal law, then you would have a timeline and a explanation of why it took as long as it did.
Yeah.
Okay. So let's move on to choosing an investigator. The key to this is that the person is unbiased and objective. There's some bullet points on here that maybe you can ask yourself, or your manager, your mayor can ask about certain individuals that work inside the city to determine if they're unbiased. This is really hard sometimes in small town Oklahoma. So
well, and I know that we've had this come up. This issue, we've addressed this several times with some of our cities where they get a complaint. It's under the policy, but they ship it over to the police department because they're trained investigators, right? Their viewpoint, I don't recommend doing that. I'll just say that. It's not, unless it's a criminal complaint, then by all means send it to the police department. But if it's an administrative policy complaint, use somebody like HR staff if you have them, or another manager in the workplace. I like to have tandem investigators, even if you can. That's not always possible. But don't send it to the police department for investigation because they're looking for criminal activity. And it's hard for them to separate what's a crime versus a policy violation. So I don't recommend doing that as just a matter of routine. I don't think that's advisable.
Yeah, there may be some instances where that's appropriate.
Yeah.
And we do have police chiefs and police officers that come to lots of HR functions.
Yes.
So they're coming to learn the HR side of it and not necessarily the criminal side. But too many times they will confuse sexual assault with sexual harassment. So they will use the elements of sexual assault to determine if there was sexual harassment. And it's two completely separate things. You can have sexual harassment and nobody ever touches anybody. So
and it gets dangerous too, because let's say you may have a sexual assault in conjunction with sexual harassment. Well, there's a criminal piece to that, and there's an administrative piece to that. So you really need to have two separate investigations. You don't need to have that melding of criminal with administrative, which we've seen happen before in a complaint such as that. So I just give that caution.
I agree. So when you're choosing an investigator, some things to look at, who's the complaining party and who are they complaining against? If the complaint is against a city manager or an elected official, I highly, highly recommend you have someone outside the city do that investigation, because what employee wants to investigate their boss?
Yeah.
I mean, I think that's probably not going to be a very good thing. Nobody wants to find that their boss, violated policy, because ultimately it's their boss and they determine whether they keep their job or don't. So I think that puts employees in a really bad spot. There are a couple of consulting groups out there that we can recommend if you do need an investigator. Sometimes, on occasion, if we have reason to believe that there will be litigation that flows from this complaint, OMAG might assign an investigator. That's not always the case. It's going to depend on who they're complaining against and the employee and the nature of the complaint. So always call us or Matt or Jeff if you have this issue, and walk us through it, and we can tell you if that qualifies for OMAG to appoint an investigator. Because again, it's really important to the litigation piece if it goes that direction. So, is it a high-level official? The only competent person to investigate the case is biased. So, like I said, in small-town Oklahoma, it could be there's few employees, and so everybody's close, and there's going to be some bias one way or the other, because you basically work with these people 8 hours a day, 5 days a week. And so you're going to know everything about them, inside and outside of work a lot of times. But even if it's not that the city has few employees, in small towns, all the kids go to school together. Many of the employees go to church together. A lot of them are related one way or another, in-laws or whatnot. So those are all going to be, things that potentially would make an investigator biased. So you really have to think about all those things.
Yeah, you just want to have somebody who has no stake in the outcome.
Yes.
Just no, not even a potential for any interest in how this might turn out one way or the other.
Mm-hmm. Because if it does lead to litigation, that's the first thing the plaintiff's attorney is going to hit on. If you find, if ultimately you find there's no policy violation, then you're going to be questioned about that. Well, what are your biases that might make you find that way? So there's all these facts in your report, but you've been going to church with this person since you were, in kindergarten. Your kids go to school together. They're play on the football team together, all the things. So that's, even if you think you did a job and based everything on the facts, you don't want to be the victim of that with your deposition being taken or on the stand at a trial. Let's see. So let's talk about page, 10, about the evidence. So evidence can be lots of things, and we'll talk about interviews in a little bit. So obviously evidence can be witness statements, talking, to people and doing interviews. But routinely what we see as also part of the evidence, voicemails, text messages are huge these days, emails, photographs, time cards. So you might use time cards in a situation where someone says, so-and-so's harassing me every time they're at work. Typically it's between 10 and 12. Well, can you go pull time cards and find out if that person is in or out between 10 and 12 on these particular days? So that's business expense records. Maybe their harassment occurred on a business trip. And it can help corroborate some of the testimony.
We had one in Oklahoma City, I think you were still there then, where we had a complaint that the supervisor was discriminating against females in the way schedules were put together and overtime was assigned. And so we had to go and dig through all of the time records to actually get those overtime totals and try to see if there was any way to substantiate that men got more overtime than women. And that in and of itself doesn't necessarily prove anything, but at least it gets you past. I mean, you've got to know that before you can go any further in determining, okay, now what do I need to ask? So there's lots of reasons why you might want to use time records and other business records as part of your evidence in evaluating a complaint.
Social media posts.
Oh, those are killer.
Yeah.
Can be.
Yeah.
You know.
And a lot of times people confuse the fact that, well, that's in my off time on my private Facebook page. But if that bleeds over into the workplace, it becomes a workplace issue.
Right.
So sometimes, as the investigator, you're going to have to review those social media posts. Let's see, payroll records, safety records, all, it just depends on the allegation. Past performance evaluations. This is why Monica and I don't like performance evaluations because they don't usually show anything. But you might have a really great supervisor who did document good performance and bad performance in the Ps, and so those might be helpful.
I mean, if you're going to go through the exercise of doing a performance evaluation, then at least make it meaningful.
Yeah.
So let's all be good supervisors and be honest, both good and the bad, because that's how that's what's fair to the employees.
And to backtrack just a little bit, as the investigator and when you're determining the scope, one of the things you need to determine up front is, who's going to be your point of contact, who can get you these records, right? So if you're reading the complaint and say it's a complaint about women not getting overtime like men, well, you should know right off the bat, okay, time records are going to be an issue. Who's my contact to get time records? Past performance evaluations, who's my contact to get the complaining party's personnel record? Who's my contact to get emails? How do I get emails off the server? So those are some things to think about when you're preparing to do the investigation. And a lot of these things I would get, if you know about them, get prior to starting any interviews so that you have that knowledge going into the interviews, and it might help you shape your questions for the interviews.
Yeah.
Okay, so speaking of interviews, and we have quite a few pages on the interview here, so we'll talk about this quite a bit. So on page 12, it starts the interview portion. This is probably where you're going to get the most information about the investigation. So most people, when you get them in a room and start asking them questions, will talk. You're going to have people who kind of clam up and don't talk and act like they don't know anything, and maybe they don't. But most employees I found want their voices heard and they want to say their piece, and a lot of them, this is their opportunity to do that. Let's see. So
I think at this point it's worth noting too, so typically you're going to interview the complainant or the reporting party first. And when you notify them to come in for their interview, tell them at that point, bring with you any documentation that you may have gathered that supports your complaint, whatever that might be. Sometimes employees want to bring someone with them.
Okay, good point.
And it could be, if it's a union shop, they may want to bring a union rep, or they may want to bring their attorney, they may want to bring their spouse, they may want to bring a workplace representative, that's a trusted friend. I mean, it can be an attorney, all kinds of possibilities there. But I always find that if that gets them in the room to be, and some may disagree with me on this, but I find that it's just most helpful to the process in general if you let them bring that person with them, but just, and I guess we may get into some cautionary things here in just a moment, but the point of the investigation is that you want to hear from the witness that you're interviewing, whether it's the complaining party or another witness or whoever, not their representative. So if that makes them feel at ease to have somebody sitting there with them, okay, but they get the same caution that everybody else is going to get, and they don't get to participate. They just have to sit there and be quiet.
Yes. And I've had that happen too, where the attorney thinks they're going to be speaking for the employee.
Yeah.
And I would advise that's not the case here.
Right.
And some attorneys will take their clients and leave. But we don't need to hear from the attorney. We need to hear from the witness. If they need to take breaks and talk about stuff, I think that's fine too. Sometimes when I was at the city, if the complaining party was bringing an attorney, the supervisor or the investigator would have one of the city attorneys come. I think that was mostly for, getting through that. We're talking to the witness. We're not talking to you as an attorney, and having that buffer of another attorney there.
Sometimes they want to record.
Yeah.
They want to put their recording device up on the table, and I don't much care for that. I've seen that allowed, but if you're going to allow a witness to record it, then you better record it too. You want your own. So that's kind of your choice. If you want to allow that, just know that the potential for compromise in your investigation is there if they take that recording and then go and play it around the workplace, or that has the potential to taint your witnesses who you've not talked to yet. All kinds of issues could be associated around allowing a recording, but that does come up from time to time as well. And I prefer not to have a recording. And as the investigator, you can set your rules. There's no requirement that you let them record.
Okay.
But if it gets them to talk to you, then maybe you just kind of have to weigh that out.
Yeah. So some of the disclaimers that you might give initially when someone comes in for an interview, obviously let them know what they're there for, that the city takes this seriously, they want to investigate it thoroughly, that confidentiality, is a big factor. Sometimes that's not always possible to keep it confidential. When you have someone come in and complain specifically about another person, the other person gets to know, in my opinion, what that specific complaint is, because that's the only way that they can respond to the allegation fully. So obviously you have, the person that's being accused should know exactly what the allegation is, because they should have a full and fair opportunity to respond to those allegations. People are people, and not everything is confidential. So the more people you talk to, the more opportunity it is that, things are going to get out. Or if other employees see employee after employee after employee going in for interviews, sometimes they make up in their own head what's going on. So there's going to be talk, there's going to be chatter, but tell the person you're talking to or interviewing that from your perspective as the investigator, you will keep it confidential, and you will do your best to make sure everybody else gets the same warning, and that there's potential disciplinary consequences if you don't keep it confidential.
Because the effect of having people come in and be interviewed and then go out and talk about what they've just talked about with you could affect the outcome of the investigation, which should be a violation of policy. I think that should be addressed in your policy, that they should not be doing things that interfere with the investigation process and going around talking around the workplace about all the things that they talked about that should have been confidential have the potential effect of adversely affecting the outcome of your investigation. People can prepare their, okay, how am I going to spin this information? It ends up not being truthful
Yeah.
at the end of the day. So anyway, just to
The only other thing I would say in the disclaimer is, be sure that you inform the employee that they're speaking or being interviewed because of an investigation, and that if they experience any form of retaliation by a supervisor, coworker, elected official, that they need to report that immediately to the investigator and a supervisor, or whoever else their policy says they report that to.
And you could give each person you talk to a copy of your policy along with your contact information, so that way they have it all there together.
Yeah. That's a good idea. So let's talk about a little more about the interviews. The subject of the allegation should be advised of the following. So this is what I talked about just a minute ago.
Yes.
So the person who's being investigated or who allegedly violated the policy, they need to be told the purpose of the meeting prior to the meeting, so that, as Monica said, they have an opportunity to bring documents, witnesses, whatever it is, to defend themselves. If they want to bring someone with them, that's their prerogative. But they also need to know that full, truthful cooperation is expected of everyone in the process, and that they should not take steps to interfere with the investigative process, meaning they shouldn't be going around talking to other employees about their side of the story, or their 2 cents before they go in and be interviewed. So you don't want them tainting the investigation. That's going to help if at the outset you have separated them, or in some instances, if it's a pretty bad allegation, if it does involve touching or maybe some sexually explicit material, then maybe that person is on administrative leave.
Yeah.
So hopefully they wouldn't have as much opportunity to talk to other employees. But between texting and email and it's so easy to do that. But those are all the things that they should be told prior to their interview. Do you have anything else that maybe you would tell someone being investigated before? Maybe
I think
no decision's been made, or...
Well, yeah. I think really the biggest caution for the subject of the complaint is don't have any contact with the complaining party. Don't even look sideways at them, because that can be perceived in a way that's not going to support your story if you're saying I didn't do what I've been accused of doing. So, I can't think of anything beyond what we've already covered.
Okay. So next we're going to touch on a little bit. There are some rights that the employee gets depending on the type of allegation it is. So on page 16, we talk about the Garrity Warning. So Garrity is some case law, and it requires the employer to give notice to people being investigated that there may be some criminal allegation and what their rights are in respect to the criminal allegation. It goes on to say that as an employer doing an employment investigation about employee policies, you can force employees to talk to you even if they may implicate themselves in a criminal investigation. But what it means is that interview or evidence cannot be used in a criminal investigation. So you can force them to talk to you, even if it's criminal in nature. But you have to give them this Garrity Warning. On page 57 is a kind of a written document that some of our attorneys use when they're talking to witnesses or doing an investigation prior to a lawsuit. So use that Garrity Warning. It's pretty generic. Have the person you're talking, the alleged party, sign this document. Even if, I don't know at what stage you decide that there might be criminal allegations, but if there is touching of any sort, or video or photographs, some of that is going to indicate that there may be a criminal law implicated. That doesn't mean they violated criminal law, but some of those things. So maybe just give the Garrity Warning up front.
It hurts nothing to give it. And in my experience, rarely has Garrity even come up in the conversation except if it's an investigation where I'm having to talk to police officers. Mm-hmm. And then they want it every time, even if there's no remote possibility that there could ever be anything criminal come up. This is strictly policy violation, but they want it. There's no harm in giving it.
Yeah, it's not a big deal.
It's
really
not a big deal. It's better to do it if it gets them to talk to you and alleviates any concerns that they may have about things that they say being used against them somewhere down the road. Just give it.
Yeah, I think a lot of people are confused about what it really is.
Yeah.
And I think they think it means they don't have to talk to you as the investigator if there is a potential criminal allegation, but it really just means the opposite.
Yeah.
It means they can be compelled to talk to you even if there's potential criminal allegations.
Right.
It just means that interview or that evidence cannot be used against them in the criminal action.
Yeah. I mean, they want to say, no, I don't have to talk to you. Well, you can give them a direct order. You will talk.
Okay.
And if you don't, then that's another policy violation we'll have to address. But just give Garrity, and hopefully that takes care of any concerns that they have.
Okay. Well, and speaking of that, there may be, if you're in a union shop or maybe an aldermanic city or even just a city that has a lot of policies regarding disciplinary action of employees, be sure you check those policies, your ordinances, your charter, and make sure there's not some other rights that employees are afforded when they're being either investigated or interviewed.
Right, and I bring up Oklahoma City again because that's where I spent a lot of my years. But in their FOP contract, it talks about employees being entitled to this under their in their contract and in the procedures outlined for doing internal investigations and what the officers' Bill of Rights. So I think that's kind of common in lots of union contracts. So it may be in there that's just part of your process.
Yeah.
So just cover it.
Yeah, so Garrity's not the only one out there. But okay, so on to page 18, we're going to talk about who should you interview. Generally, I say you interview the reporting person first. There may be situations where you wouldn't do that. Maybe they're not available to interview first, or maybe just as a strategy, you want to interview them last. I don't know. That's going to be your decision as the investigator. Anybody who has firsthand knowledge, the subject of the investigation, any witnesses with relevant information, supervisors, any other thoughts on that? You want to be careful not to interview everybody. So, again, look back at your scope. What are you investigating? Who are the parties to the investigation? If maybe you find 4 or 5 people that come up in different interviews, ask those individuals, okay, well, if I interviewed Bob Smith, what do you think Bob would tell me? And if it is something that you're supposed to be interviewing, if it's within that scope, then maybe you go talk to Bob. But if they tell you, well, but Bob can tell you how bad of a supervisor this is because Bob worked for her 20 years ago.
Yeah.
Okay, well, that's probably not relevant. I wouldn't put that at the top of your list of people to interview. So maybe keep an ongoing list. I think initially you're probably going to have, 4 or 5 people that you want to talk to, depending on the allegation. It could be 2.
Typically, as you said, you may not want to start with the complaining party, but I think most of the time you will, because that's going to help you really refine the issues, because they're why we're in this, and then, as you said, who knows, who do you want me to talk to? Who do you think we should talk to, and what will each of them say in relation to what you're complaining about, and try to keep them kind of focused in on the issues as well. But I think it just kind of, that's a good place to start, is with the complaining party and who they think the witnesses should be.
And sometimes you might interview someone who might not know anything about the allegation,
Right.
but they know these parties.
Mm-hmm.
So if you have a trusted supervisor who maybe wasn't, there when this incident occurred, they don't really know anything about it other than secondhand information, but they know these employees. So you might want to talk to the supervisor about, what's their daily working relationship like? How do they get along with other employees? Because in the end, that's going to help you kind of corroborate
Well, because
the
as
credibility.
the fact finder, you've got to consider, the credibility of each witness, and so sometimes having somebody who really is on the outside but may have this relevant information in relation to the character or of witnesses or the complainant or the respondent, that kind of helps you sort through the information that you gather so that you can kind of weigh, well, this is more likely to be true than this, or that kind of thing. Kind of helps.
Yeah, I agree.
As an evaluation tool.
Yeah. So where should the interview take place? We get this question on occasion. Likely in a place where other employees don't see people coming and going all the time, the least disruptive place as possible. I've hired an investigator one time where there was really no place in City Hall for her to talk to people. So they found a local cafe in town and kind of went between breakfast and lunch, and that's where she would meet. There wasn't hardly anybody there. They felt like it was across the street from City Hall, so it wasn't far for the employee to leave from work. But so sometimes you might have to get creative. I prefer to meet in person. When you have COVID and things like that, sometimes that can't happen. Or if you have a person who's deployed, you don't have any other choice but to do that. If you can do Zoom or Skype or whatever the capability is, that's good. So you can lay eyes on the person and make sure that's who you're talking to, the right person. And you can see some of their mannerisms. But I really think having a place to go where people don't feel like some other employee is going to walk in on them or hear them through the door or the walls is the best setup for that.
I agree with that.
What questions should you ask? I'm a preparer in advance of questions. I always have been. A lot of people can wing it and be just fine. Maybe you just have a few bullet points, some hot topics that you want to hit and kind of fill in the blank. A lot of times I'll write out a whole bunch of questions and maybe use 4 of them because a conversation will start. And so they're really just kind of reminders. I find that if I don't write it out and all I see is 1 or 2 words and a bullet point, sometimes I don't remember what that question was going to be. So obviously, yourself the best, and whether a few words can jog your memory or whether you can do it off the cuff.
Yeah, I think it's good at a minimum to have an outline. I tend to use that approach more than writing out specific questions, but to each his own. Whatever works for you, then that's how you should do it. But make sure that you are taking good notes along the way, and at least kind of have this overarching plan going in so that you've got the key points that you cover. You don't want to ever find yourself after your witness has left the room thinking, oh, I did not ask that really important question, and then you have to call them back.
Yeah.
So at least have an outline for your plan. I think is a good.
Yeah.
Good.
And to that point, we can talk about this in a little bit, I think, but there may be a reason to call them back in.
Sure.
So if they have left or some other question comes up later, you need to keep running questions of, okay, second interview, I need to ask these questions or get clarification.
Right.
What I think you have to keep in mind when you're asking questions, though, is, use open-ended questions, not leading questions. And so as attorneys, we're taught not to use leading questions unless you're on cross-examination. But for open-ended questions, it's, basically don't ask specific questions. Say, tell me what happened. Because they're going to give you a lot more than if you say, tell me what happened regarding this allegation you have against Christy on such and such date. Because then they're just going to focus in on that, and you might not get kind of the other stuff that you need.
Yeah.
So open-ended questions.
Yeah.
So
None of the when did you stop beating your wife kinds of questions.
Yeah.
You know.
I mean, you do need to ask the who, what, when, where, why questions.
Oh, yeah.
So who was there? Don't say, was April and Christy and Jennifer there? Ask who was there and let them tell you who was there. What was your response and what actions have you taken since? Very open-ended questions. Has your job been affected by these actions? So let them answer in their own words.
And they typically will. In my experience, when you just kind of open it up and then give the witness the floor, then just listen, because they're going to spill most of the time. They kind of gear up and get going, and then the information really does start to flow if you aren't impeding that with limiting questions.
Yeah. So that leads into documenting the interview, because what typically happens is when you ask open-ended questions, they just start talking. And so as the interviewer, you're trying to take notes and listen at the same time so that you can put all these pieces together, for your analysis and report. So just a few things to help keep you on track when you're documenting the interviews, the name of the employee, the date that you interviewed them, the time that you interviewed them, the location you interviewed them. I found, that might seem a little over the top at the time that you're doing it, because you're like, well, I'm here. I know they're here. We're talking. Why do you need to know? But if you end up in litigation 2 years from now, and you're on the witness stand talking about your report and how you came to certain conclusions, if you can go back to your notes and say, well, I talked to, Brad on April 1st, and it was at 10:30 at the local cafe, that's going to make you look a lot more credible than if you say, I don't know, when I was interviewing people for this investigative report. So, 2 years from now, you're not going to remember it was at 10:30 on
Right.
April 1st. I say take detailed notes, because again, 2 years from now, are you going to know what those bullet points mean, or your chicken scratch? I know I didn't. I was taught a long time ago in union negotiations, make sure if you do just make little notes, that when you get back to the office, you type out word for word what you remember from the discussion. And so maybe as the interviewer, that's something you can do. You can write bullet points and little notes to yourself when you get back to your office, kind of dump everything, written out in a paragraph or sentence format.
I mean, what works for me is, having my outline and kind of knowing the topics that I'm going to cover, but then I really do like to try to write as much verbatim as possible. I don't want to just say, oh, the employee was upset about this. Well, that would be my take on it. But how do I know that? Well, because the employees write what the employee said is what I'm trying to say. Be very specific in your notes. I think that more quotes you write down, specifics that are said, the better your report will be, because you'll put that in your report, and it won't be your summary of what you heard. It will be exactly what they said.
Yeah, and so on page 23, I've read so many investigative reports where they say, well, one, it includes a lot of opinions, or conclusions that are reached, but you don't know why the investigator reached those conclusions. So, if you're going to note behaviors, which I think are important, so you're judging the credibility of the person, don't say, I found, Christy very evasive. You could say, Christy didn't answer my specific questions. She kept changing the subject. I found this odd or evasive. But make sure you explain why you find it evasive. Carrie seemed really nervous. She was, clicking her pen. She wouldn't look directly at me. At some point, she had to excuse herself because she felt sick to her stomach. So, describe those things in detail so that it comes through in your report why you felt like they were nervous. Let's see. And big deal. Don't draw conclusions unless you can follow it up with the reasons why you drew those conclusions. Make sure that you have the evidence to support that. Don't make assumptions. So, okay. So how do we close the interview? What are your thoughts on that?
Well, first of all, thank the witness for coming in and giving you their time for a really important process. I think if they feel like they have contributed something that goes a long way in dealing with whatever the fallout may be down the road when things start to have to be addressed. I always give witnesses, as I said, I give them a copy of the policy, but I also give them my business card and with my contact information on it, because I want them, if they think of something, lots of times that happens where they leave and they start kind of, debriefing themselves, and then they think, oh, I didn't tell her this or that, then they can contact me. So make sure that they have your the interviewer's contact information. If you've taken notes, I like to have them review my notes right there on the spot, even though they're not typed up. If I've written down some things that I'm going to attribute to this witness, then I would have them take a look at the notes and sign them that they did review them. Even though they're my notes, they could actually verify that I got that right. In my
especially
notes.
if they've said something very specific that in your mind you would put in quotes because
Right.
you attribute it directly to them. Maybe kind of follow up in a way that they could confirm that
Right.
that's
Right. I think that's a good rule of thumb. Also, lots of times through interviews, a witness will say, well, I've got this documentation, or I've got this piece of evidence. I don't have it with me. Then, have a list that of things that you've asked them to provide, and make sure that they walk out of the room with that list in hand, so that they'll know, okay, I need to go and get this, and this, and get that back to the investigator. And then I think just kind of summarize next steps with them. So, we're going to be interviewing more witnesses, then we will evaluate everything and prepare a report, and that report will go to the city manager or the mayor or whoever it goes to, and kind of let them know what those next steps are.
okay. Let's move on. So now that we have the evidence, we have the scope, we have the interviews, you think you have everything that you need as the investigator to kind of draw your conclusions and relate it back to the policy and determine if, in your opinion, there was a policy violation. Now, to be clear, it could be that your scope is to gather facts and that you're going to give those facts back to management, city manager, mayor, city attorney, and they're going to use the facts and the policy to determine if there's a policy violation. So be clear in the scope if they want you to determine if there's a policy violation or if you're simply a fact gatherer. I would think they would want your impression about whether there's a policy violation or not. But just be clear about that and what's expected as far as an analysis of the facts and the
That's
policy.
a really good point, because we do know that happens where someone is assigned to go and gather all of the facts but not make findings of fact, and that's going to be left to somebody else. And so that's a really good point to know your limits.
So I'm on page 26. So when you're evaluating all of your evidence and your witnesses, you're going to use the more likely than not standard. So, for criminal, it's beyond a reasonable doubt, right? So this standard is kind of like you're just going to have to use your best judgment based on the facts, based on the credibility of the witnesses. So that, look at it through that lens. You need to evaluate all the witnesses. Was the information they provided credible? Was it relevant? Was it truthful? Was it plausible? Was it possible that this person could have said or done things when you have time records that show they were on vacation that week? So, look at all those things. Was there motive? Always something to look at. So review documents to determine which ones are relevant. So in this process, you may have gathered who knows what, personnel files, time records, social media posts, policies. You may have a whole stack of policies. In the end, 2 were relevant. So you're going to have to do that. Do any follow-up interviews that we just talked about, and consult with a trusted advisor. So someone that will keep it confidential, really has no stake in the matter, but that you trust their opinion about whether it's a legal issue or credibility issue or, what should be in the report. So do you have any other advice on that, Monica?
And I think we talk about this in the report section, but I would just caution, as you are evaluating all of the information that you've gathered, don't draw your conclusions. I like to kind of work through that as I'm doing the report. I may think, oh yeah, as I'm evaluating a clear policy violation, but then when I really start to put all of the information and it starts flowing down into the paper, I get to the end and I'm in a different place than I was in the beginning. So just keep your mind open and just let all of your facts that you've gathered come together, and they will come together.
Yeah, because so many times, there's bad behavior, but it might not be a policy violation. Yeah. So it's things that are inappropriate,
sure,
that probably shouldn't be happening in the workplace, but it may not rise to the level of a policy violation. Or it might just be people, as an investigator, you're like, oh.
We say, oh, you've got a complaint of sexual harassment, a male supervisor who is harassing female employees. And then as you've gathered your facts and you start writing the information out, then it becomes very clear that no, he's not just a jerk to females, he's an equal opportunity jerk. And so that may not violate the policy on discrimination and harassment. Now, you may have another policy that says we don't like for our managers to treat our employees, less than respectfully and that kind of thing. That's a different issue. Mm-hmm. It's not going to be a violation of that particular policy that defines your scope.
Yeah, good point. Okay, so page 28, we can talk about the report. So this is the most arduous part of the whole thing, is getting all of this written in a report. Yeah. It seems to take a lot of time, and honestly, to write it in a way that only contains the facts, that describes characteristics like we talked about. You're not just saying she appeared nervous. I mean, so it takes, a lot of thought because the words matter. Because it's the final word. It's the document that's wraps it all up. It's the piece of evidence that's used to determine if there's a policy violation, if the employee is going to be disciplined. So it's very important that, all the things are in place with this document. And let's see, I think there's a sample example format on page 55 and 56 of the book here. And I can't remember if I got this from Margaret Love or one of our other attorneys, but this is kind of the format that they use. And so it, obviously the date, investigator name, and it just is kind of a template so that you don't forget some of these things as you're writing your report out. And what I like to do is go in and fill in all the things that I know that are easy. So I feel like I also like to check things off a list. And so this helps me kind of work through and feel like I've accomplished some things with the report and get you started. So that's a good investigative report. And then the investigation summaries on page 56. So, but the report, just make sure, it has all those components in it. Again, make sure that, get back to my page here. Detail out all the witnesses that you met with, their name, what department they're with. Again, facts only, no opinions. So for example, I put in here, John Smith appeared uninterested. Well, that's my opinion as the investigator. That could just be John. But you could say things like he kept checking his watch. All of his answers were, I don't know. That would lead one to believe maybe John was uninterested, without saying John's appears uninterested. Use quotes whenever possible. And, insert the relevant policies. I usually would say word for word. What those policies are, policy numbers. Avoid inflammatory or judgmental words. I used to have a report that had some really inflammatory, terrible things to say. They were really personal attacks on certain employees. And I thought to myself, I can't introduce this as evidence because it makes the supervisor just look like a mean, terrible, awful person. Don't draw legal conclusions. Remember, we're not looking at violations of law. We're looking at violations of policy. If for some reason you don't believe a witness, or think they're not credible, don't say, Mark's not credible. Say, I found that Mark told me this. It doesn't seem to match up with the payroll records or the time records or what he said on social media. So, pull all those things together. Do you have anything?
I mean, to that point, just if there's if Mark has said something and you've gone and talked to other witnesses or evaluated documentary evidence and that kind of thing, if it's not substantiated, then say that. I was not able to substantiate what Mark said about this. That doesn't necessarily make Mark out to be telling, untruths. There's just nothing to support what he's saying.
Okay, yeah.
And you have to have that support to be able to substantiate the complaint so that you can determine if there's a policy violation.
Yeah, exactly. Yeah. And then in the end, obviously check it for grammatical errors, misspellings, because the last thing you want as an investigator is to have to testify 2 years later and the plaintiff's attorney, all he's pointing out is where you didn't use capital letters or you misspelled things. So, try to spell everybody's name correctly.
Get the names correct.
Yeah. So when you sit them down and interview them, have them spell their names for you. and get their job titles, and get how long they've worked at the city, so that you have that information in your report. Let's see what else. Be brief, but at the same time, you need to tell the complete story and write it in a way to tell a story if you can. Typically, you'll have a couple paragraphs of each witness, so you can kind of build on that. Make notes whether policies were followed or protocols were followed or procedures were followed. I mean, so many times in investigative reports, we'll find that, they can't substantiate any harassment or discrimination, but there's all kinds of, partial treatment or, favoritism, I guess is what I'm trying to say, for certain employees. Certain employees are treated differently than other employees. And so you might see a theme as the investigator that maybe the supervisor needs some supervisor training because they don't know how to supervise individuals. They don't communicate very well. And so a lot of times it just boils down to that in the end, is that you don't have a strong supervisor, and it's just led to really kind of people kind of running amok in the workplace.
Yeah, I think we see that a lot. And another thing that pops into my head, because I do feel so strongly about our employee assistance program, that you may need to make some recommendations about that be included in part of your remedial process for some involved party in the whether it's your complainant or your responding party or witnesses. That's an additional tool in your toolbox that can help you work through workplace issues.
Yeah,
if that's what you have.
And so, just to kind of wrap up the report piece, so the report that you finish, sometimes we'll give a recommendation about a policy violation. Sometimes, if your scope includes recommendations for discipline, then you might have a recommendation for discipline in there. But that report is a confidential personnel investigation. So do not put that report in the personnel file.
And do not give a copy of that to anybody except whose authority you're investigating under. So your city manager, your mayor, whoever you're giving the report to. The complaining party doesn't get a copy of the report.
Yeah, so the complaining party doesn't get it. The person alleged of discrimination or harassment doesn't get a copy either. I'm a fan of doing a simple letter. There's an example on page 62 of a closing letter that you can send the complaining party and the accused, just to let them know that the investigation's wrapped up, the report is done, and that your recommendations and findings have been given to whoever gave you the authority to do this investigation. That can go in the personnel file. Sometimes it will say, I have finished my investigation and I can substantiate a finding of a policy violation. And it goes on to say an appropriate action has been taken to resolve the issue. I don't know. It could say lots of things, I guess. that kind of communicates to the employees that the investigation's done and action has been taken. Now, if the employee wasn't fired, what usually happens is the complaining party thinks, yeah, right, you didn't do anything. Well, they don't know that the person didn't get suspended for 7 days or demoted or whatever it is. It's not their business.
And they're not entitled to know.
They're not entitled to know that. So that's important that I think that you follow up with that closing letter. Now, I will say, if the issue results in litigation and there's a lawsuit filed, that report is going to be, for the most part, open. So we can move to have it put under seal sometimes, or so that it's confidential. Judges don't always do that. Likely, if it goes to litigation, everything in the report will come out, because they'll be asked certain questions in depositions and at trial about things that are in the report. So again, we try to keep it as confidential as possible, but if it goes to litigation, eventually it won't be that confidential.
Or maybe, under, you have a police contract or a fire contract and discipline's been issued. If the arbitration at the end of that process, then the information's going to come out.
Yeah.
So everybody just needs to understand that that's what's going to happen.
Yeah. So, okay, Monica, now we've talked through the whole process of the initiation of an investigation, the scope, how you evaluate the witnesses, the report. And so I just wanted to go through a couple of case studies to kind of put that into action. So let's start on page 36 and 37 for the first case study. So this is actually a grievance letter that a Christy Smith sent the mayor and the council. The reference is hostile work environment and hostile workplace and slander, January 8th, 2017. And she says, I'm writing each of you this letter addressing the hostile work environment that I work in each and every day. I have discussed this matter with an attorney, but I'm not prepared to move forward. The attorney directed me to notify my supervisors that I am requesting that the hostile work environment and slander stop. I work every day in a small office with Melissa and my supervisor. Becky, do not speak to me. Also, my supervisor in front of the police chief accused me of having an affair with the mayor. There's no proof of this allegation. Therefore, it is slander. She says that she encloses some information about slander. According to the EEOC, a person is qualified to sue for damages if they have proof of being defamed verbally and can show they suffered damages. Then she talks about defamation. I was informed that I did not qualify for the code enforcement position because Becky accused me of sleeping with the mayor. Again, no proof of this. This meets the criteria for damages to me personally and professionally. Councilman White informed me that my name was named in a lawsuit. It stated that I was having an affair with the mayor. Let's see. I do not want to come to work anymore, but I refuse to quit because that's what Becky wants me to do. If I make mistakes, please counsel me. Let me know about my wrongdoing. Let's see. I can't fix it if I don't know what I've done wrong. I request each and every one of you please research slander and hostile work environment. An investigation would be appreciated. Ask the police chief, police officers that come and go from the building every day about the stone silent treatment I have to endure. I wanted the code enforcement job to get out from underneath Becky, but I've withdrawn my application. Please take this matter seriously and feel free to get statements from my fellow employees. This is an official grievance letter to the city. I have rights as an employee and a right for the council to investigate and attempt to resolve the issue. So we have a letter. So we're going to kind of walk through each step. So here's some things that we do know, though, right off the bat. We know she put something in writing to the mayor and the council. We know who the employee is making the complaint. As you stated, sometimes it's anonymous, so we don't know who it is. The allegation is hostile work environment, slander. That's usually, we'd have to look at your policies and decide if you have policies against slander. It might be something more like a bullying or dishonesty or something like that. When is it occurring? She says each and every day. She is requesting that it stop. She says that employees don't talk to her. She's accused of sleeping with the mayor. She's alleging that essentially she was passed over for the code enforcement job because of some of these allegations, that she would like to quit, but she can't, and that she requested an investigation. So to kind of fill in some of these. So for the initiation, I would say it's a written grievance. I mean, would you have anything to add to that?
No.
I mean, the fact that she sent it to all the council members, that's something else to note, that she's brought it to that level.
A thought just popped in my head, not necessarily related directly to this, but because you said sometimes it's anonymous, like we said earlier, on a tip line. Mm-hmm. Just because it's anonymous, though, doesn't mean you wouldn't proceed with an investigation. I don't know that we necessarily said that earlier.
Okay.
But so you may not know who to talk to in terms of complaining party, perhaps. But you should still go ahead and conduct an investigation and talk to who might be indicated. I just thought better slide that in there while it was in my head.
Yeah. Just because you don't know or because it's not written down doesn't mean you don't have to investigate.
Right. You still have an obligation to investigate to the extent you're able.
Yeah. So scope of the issues. What do you have as some of the scope of the issues?
So hostile work environment, that she puts that in the subject of her complaint, mm-hmm. As well as the slander. But I think you've also got issues with potential promotion, because she wanted the other job and withdrew her application. I'd want to explore that with her. Why did you withdraw it if you really wanted out? So
mm-hmm.
I think that's an issue. I think you need to find out what the nature of the relationship is with the mayor. Maybe you talk to the mayor first. Anyway, I think that's got to be on your list. She references this other lawsuit, this Bobby Brown lawsuit. What's the time frame around that? I'd kind of want to pin down. This is kind of a shotgun blast to me. She's throwing out lots of different issues in this letter, so I would want to try to pin down what is our time frame here. When did it start? What's the time frame for this lawsuit, since she relates back to that.
Yeah, and if you go back to page 6 and 7, we talk about some of those things in the bullet points. Obviously look at your policies, or they would look at the policies and decide which policies are implicated. Are there any directives or ordinances that talk about how promotions are given and how you apply for those? Look at what the obvious issues are and maybe what some potential issues are. Yeah, so I agree with those. So then investigator. My thoughts on investigator, I don't know. I just always lean toward an outside investigator. I know that's not always practical and possible, and it's not always needed, obviously. But, maybe go back to pages 8 and 9. Do you see anything, or can you think of anything that would pop into your head about an investigator?
She's written this letter to the mayor and council, but unless I don't think I missed it here. we don't know what the form of government is.
No.
So that may not have been appropriate. This may not be an appropriate issue for the mayor and council to even be thinking about. If it's a city manager form of government, they don't need to be involved in personnel matters. So that obviously in your city you will know. I hope you will know. So that's something to think about right off the bat if this is not an appropriate subject for the mayor and council. So if it is appropriate for them, then I think probably an external investigator would be most appropriate. If it's a city manager form of government, that doesn't mean that you wouldn't still investigate, obviously, but probably consult with your city attorney, formulate a plan that way. If you've got someone in HR or key manager it still gets pretty delicate since you've got an elected official involved. But I think for sure if it's an appropriate issue for the mayor and council to even be considering, I would get an external investigator.
Yeah. So we don't have any indication that she's alleging anything that the mayor and the council did wrong.
Right.
That just is the avenue she chose to report the complaint to. So, okay. Evidence. So on pages 9 and 10, we talk about the different types of evidence, or 10 and 11, I should say. So some of the things indicated here might be emails. Did she express any of these concerns to her supervisor, Becky, and her, coworker about the silent treatment? Are they communicating through emails? Does the non-verbal communication seem to be affecting the job performance, or are they able to communicate through email and get the job done?
I would want to see personnel files for each of these folks. Again, she brings up this Bobby Brown lawsuit. We don't know what that's about. Make sure we know what that's about.
Yeah.
I would want to see what documents there are in relation to the code enforcement job.
Yeah. Who all's applied for that?
Right.
Yeah. What the qualifications are.
Right.
For that. Did she actually apply for it? Was there an application filled out? Was there an email saying, I want to revoke my application? Because that would corroborate whether she actually did apply and whether she revoked it, or if she's just saying that that's what she was going to do. I would interview all the parties mentioned. I don't know that I would interview all the council members, maybe the mayor.
Yeah.
And if the mayor has more insight.
Maybe social media posts, if there are any. Does Christy Smith have any written documents? Make sure that whatever she has to support her claim, that you get it.
Yeah. Maybe the police chief. I think I would definitely talk to the police chief actually and get his impression or her impression of, the situation. Do they feel like the other employees treat Christy with this coldness that she's talking about? Okay, let's see.
This might be a place where you want to look at time records. I don't know if they work shifts or not, but do they all work at the same time? I mean, are they there present at the same time, or are they on different shifts? Just verify when these things could be happening, if they could be happening.
Yeah, and one thing we didn't talk about either is sometimes when I would do an investigation and I'm not familiar with the department, so say you're in a bigger city and they ask you to investigate something in the public works barn, and there's all these allegations about things just like this, about, they're cold, they don't talk to me. Okay, well, physically go there, and are the desks and the offices set up in a way where they would have an opportunity to talk to each other?
I think that is such a good point, because oftentimes we, as investigators, we think, oh, we're going to just go in this private office over here and all of the witnesses will come to us. But that is a perfect example for why you may want to go out to where they are, and you probably should, because then you are kind of in their shoes, so to speak, in their environment to see exactly what they work in.
Yeah. So don't be
It's a very
shy
good point.
about
Site investigations are
Yes.
always a good tool.
site checks.
Yep.
Okay. Let's see. So the interviews. So we just talked about they should interview Christy, maybe the mayor, maybe some other council members if they think it's necessary. I mean, what if it turns out she has had an inappropriate relationship with the mayor? Maybe you want to talk to some other council members to get their impressions of that. Obviously, the supervisor, the coworker, the police chief are just some of the ones that I had. Do you have anybody else? Where, we talked about when you're pulling in people to do interviews, maybe not always the best at the work site to do interviews. It could be appropriate if you feel like there's an office space that you can get that quiet, time with the person, uninterrupted time. But it's also a good idea to go do the site check and get kind of a layout for the building and the office space. So what do you have for maybe some things you might ask about? What you might ask about?
I would ask, well, I let me get back over here to the statement, but I would try to get more to the heart of the relationship in this office. Try to glean some facts on the dynamics. What is the history? How long have they been there? I would like to get Christy's insight on why she thinks this is happening. Talk to each one of them and see if you can kind of pin it down to a point in time when things may have gone awry for whatever reason. I think you've just got to try to get to the heart of those relationships and what might have precipitated this conflict in the workplace. I mean, Christy may think all of these things are going on, that she's the victim, and this may be news to other people. So you need to kind of know, okay, well, this is her, this is what she's saying, but what does everybody else think about that? Again, talk to the police chief, talk to these other officers, ask them what facts, what direct knowledge, firsthand knowledge they have about the issues where their names have been mentioned in the statement. Do they have any firsthand knowledge, or is it all just rumor mill? We know how that rumor mill.
Well,
works.
and to get to the part about the code enforcement, because that's potentially an adverse action that she's alleging resulted from this, I guess, harassment or bullying or whatever, slander.
I would want to know from her, why did she withdraw her application if she really wanted that position, because it would remove her from this office where she's complaining about. What caused her to remove her application?
Yeah.
We don't really know why she did that. It doesn't lend itself to I don't know. Why would she do that if she really wanted out of that office?
Yeah, and if there is an HR department or an HR person, I would want to talk to the HR person to say, did you have a conversation with Christy? Did anybody in your department or decision maker that you know of, encourage her to withdraw her application? Is there a job description that I can look at to determine if she would be qualified for the job?
I mean, that is important to know if she would even meet the minimum qualifications for the job, and a copy of her application.
Yeah.
Or you want to verify that she did apply.
it could be there's a collective bargaining agreement in place too, that
That's true.
she would not have been the next person in line for the job. So there could have been lots of reasons, I guess, is the point why she withdrew her application. But if none of those pan out and she's saying I did it because they told me I wouldn't even be considered, then, maybe that's worth something.
In her statement, she says, "I'm always on time and I do not miss very many days." So you need to verify her time records and talk to whoever would be the keeper of those records to make sure that, they're accurate and,
Yes.
and in order.
So then we're going to move to the evaluation of the facts and the documents to determine if there was a policy violation, right? Not the law, but a policy violation. So is it more likely than not that all of this information led to that you've gathered is a policy violation? What documents do you have to kind of go with that? Some of the ones we talked about, job descriptions, evidence, talking to witnesses. Let's see what else I have.
I think it's always important to make sure you understand what does she want as a result of this investigation.
Mm-hmm.
Make sure you've covered that so that you can include that in your evaluation. I mean, she may want to be paid, she may want to increase in pay for a job that she didn't get. I think you need to make sure that you include what her ask is. I mean, she says, "I want it to stop," but I think pin her down and make sure that you're clear on what her expectations are, so that way you have a complete report that doesn't have any gaping holes in it.
Yeah,
somewhere
well,
down the road.
That might tell you what her motive is too.
Absolutely right.
If you're seeing that the evidence isn't bearing out in her favor necessarily, well, maybe that gives you a reason why it wouldn't bear out that way.
Yeah.
Okay. I think that's case study number 1. So number 2, it's a claim of sexual harassment, and I've worked for Weber County for 24 years as a court administrator under the direct supervision of Judge Story. I have been subjected to offensive touching and unreasonable questions about my activities away from work. The judge began acting inappropriately toward me in early 2016. He became touchy, would often stand so close to me that his groin rubbed against me. He once called me into his office and told me he had a dream about me in which I was naked. I also found a poem by Judge Story which revealed his romantic feelings for me. He asked me all the time where I was going. Before 2016, I could work flexible hours and could miss work without obtaining prior approval. But in 2016, he told me that the frequent absences were becoming a problem and I had to get his approval before I missed work. But this was just a ploy so he would know where I was going and what I was doing and who I was with. This new policy is just his way of being possessive in an attempt to control me. I went to the city attorney's office and complained of sexual harassment. I was immediately placed on paid administrative leave. This is retaliation for me telling the city attorney. So if we start with the initiation, I'm assuming this was written, but we also know there was a component of it that was verbal to the city attorney. So we may have had both in that situation. We didn't really touch on this, but if someone does come to you with a verbal complaint, you can ask them to put it in writing. You should probably ask them to put it in writing, but it's not required. If they're not going to put it in writing, then I would say you need to write down everything they told you as soon as possible, and maybe even read it back to them if you have an opportunity, and and see if they will sign it. If they won't sign it, then at least put that they were a witness to it or whatever facts that you have. If they don't want to be a part of anybody writing it down, you still need to write down what you know and when you knew it and what the allegations were.
Yeah, that's right.
So reduce whatever verbal communication you have to writing as soon as possible about the complaint.
So we don't know how this written document came to be. It doesn't identify who it is. I mean, obviously we would have to kind of pin that down with the city attorney to get started, but this is typical of people live in their own little bubble and they think, oh, well, isn't it obvious that this is me? But no, it's not. And so, pin that down right off the bat, who this is.
Yeah, and we don't know when.
Yeah, we don't. We don't have a date. It dates back to 2016, but is it today that we've just received this? So 5 years later?
Yes.
I mean, that's what it looks like.
Yeah. Okay, so the scope. So we know she's alleging sexual harassment. We know she's alleging retaliation. This is when it gets to allegations of touching, that's pretty serious sexual harassment.
Yes.
And I think that is an instance where you definitely need to separate employees from the get-go.
Yes.
In this situation, what came to my mind was, okay, well, they need to be separated. She's a court clerk. He's a judge. Can we find someone to step in for the court clerk? Probably easier than finding someone to step in for the judge.
Absolutely.
So sometimes it's a matter of how do we keep things moving at the city so that there's little disruption to citizens or to other employees, but continue to protect the complaining party. So if she was likely put on leave, it was likely leave with pay, if I had to guess.
I would hope so.
Yes. Yeah. So you just need to document why she was put on leave and why, she was chosen as the person who had to be put on leave because, likely that was the easiest solution to a bigger problem, not having a judge. So, but that in and of itself could be a viable retaliation claim. But if she's on admin leave with pay, she's not going to lose leave, leave time. She's not going to lose pay. She's still in a paid status, so she'd still have the seniority and all the things like that. So just make sure it's not an indefinite administrative leave. I mean, at some point, this will run through the process and a decision will have to be made whether these two people can work together or not. So investigator. So I also thought of, well, who wants to be the person who investigates the judge in town? So I think this is a prime example of why you would want an out-of-town investigator to come in, someone who's not driving through town getting tickets or assuming this is the local, the local judge. But so this would probably be a good opportunity to find someone external. Do you have any other notes on that?
No, not other than just making sure we get the clarification through the city attorney about how it came to him or her, and make sure we include the city manager if that's the appropriate form of government.
Yeah.
In that meeting with the city attorney. I wonder who is the judge appointed by the governing body? What is the nature of his relationship? And, just make sure everybody wouldn't necessarily know. So just make sure you understand, how is he even a judge? How did he get this position? And make sure you understand who he reports to right off the bat as well.
Yeah, that's a good point. And that those people are aware that this investigation is taking place.
Yes.
Right. Yeah. Evidence, obviously policies that have to do with harassment, the leave policies, because she indicates that she at some point could come and go as she pleased, and now all of a sudden,
Yeah,
you
what
know,
happened in 2016 that caused the relationship to
deteriorate.
yeah,
Yeah. Something that also could have happened was a new supervisor in place, a new city manager who came in and said, this willy-nilly leave policies has to stop, and it's stopping today. So everybody across the board is going to enforce these leave policies. So it may not have had anything to do with the judge at all. It could have been a new city manager, mayor in town who was doing that. So if that's the case, there may be a directive or memo put in place that would be relevant evidence.
I would check the personnel files.
Yeah.
For them.
So past practices, was she the only employee that had the ability to be flexible? Was she the only employee in this office?
Right.
Are there other employees in the office that also have the same flexibility? And do they still have the same flexibility, or are they now held to the same standard as her?
Check social media, emails, work emails.
Yeah.
Something I had noted here from past experiences, are there cameras in the workplace? Can we verify that he was too close and that he's touching her with his body? Can we? Is that on camera somewhere, on film somewhere?
Yeah, that's so true.
Did the city attorney provide her with anything when she came to talk to him?
Yeah.
Any document exchange that might have happened there.
Yeah. And who did he notify, and
right,
what steps did he take? And was he or she in the loop through this whole process? Was he or she in the loop when the new manager or mayor came in town and said, I want a review of all the policies and I want to make sure everybody's following them?
Right.
So the city attorney might have a wealth of knowledge there. So then when we start interviewing people, we obviously want to interview the judge and this complaining party. I had the city attorney. I had other court staff.
Court administrative staff.
Yeah. So obviously I would ask them what their impression of was about the relationship between the judge and this employee. What did they witness?
Right.
Was he doing it to
judge
them?
And anybody else? Yeah.
Yeah.
With the city attorney, I'd want to know what did the city attorney do when this employee came to him? Who approved the administrative leave? What happened, internally that got us to this point? And I think the city attorney should have some information to shed some light on some of that.
Yeah. Yeah. I mean, one thing to keep in mind, wasn't she? She had worked for the county for 24 years. Mm-hmm. So she had lots of years of experience. It doesn't say how long the judge had been there.
Right.
But, what is how many departments and judges had she worked for in 24 years? And was this accusation ever made before? What's her credibility?
Right.
Okay, let's see here. So to evaluate all that, I think, again, you look at the policy on harassment, on absences, or any other relevant policies that you know of, any directives or ordinances or city charter things that might be relevant. There's lots of questions here, and I've been in this situation, and you have too, or heard of them, where it's not unheard of for people to have consensual relationships that go bad. And so it's one breakup away from a sexual harassment complaint. And I'm not saying that's what's happening here, but that's always a possibility.
You need to verify one way or the other. Absolutely that point.
Yeah. And if there was a consensual relationship, there will be emails, there will be text messages, there will be phone records. They will have told someone.
Yeah.
There will have been lots of meetings behind closed doors. We know what all the signs are there. So I think a lot of the time people usually admit to it because they know they're going to be found out.
Right.
So that doesn't always mean there's a finding of sexual harassment. It really just depends on when did the breakup occur? Was it made clear to all the parties that they were broken up? What kind of evidence do you have to support that?
Yes.
Yeah. Anything else on that?
No?
Okay. So we have one more case study we can look at. Let's see here. This is I called it snake stress.
Yes.
Yeah. So you have Johnny Mack, who worked for the town public works department for over 20 years. He's African American. In June of 2017, he began reporting to a newly hired public works director, Kenneth Patterson. One day, David Davis, an employee of a local temp agency working for the town, found a garter snake on town property and placed it in a bucket. The next day, Patterson assigned Johnny to sweep the gutters on a road. Johnny went to get the sweeper, parked it in front of the shop, began cleaning the windows. When he finished cleaning the windows, he placed the window cleaner on the passenger seat and left to use the restroom. Mr. Davis, who's this temp employee, placed the snake in the sweeper while he was away. Johnny had previously told Mr. Davis that he was afraid of snakes. And so when Johnny returned, Mr. Davis asked Johnny Mack if he would look in the window, if he could use the window cleaner. When Johnny Mack reached into the sweeper, saw the snake, and screamed. He turned around to see Mr. Davis laughing and Mr. Patterson, his supervisor, the public works director, and another coworker were present and laughing as well. He suffered chest pain, eventually went to the doctor, later filed a workers' comp. After a doctor's visit on August 25th, Johnny did not return to work until the following month. His workers' compensation paperwork stated that the snake incident occurred on August 10th and that his chest pain was attributable to that. Johnny was released to return to work under the condition that he work in a mostly stress-free environment. He requested a transfer as an accommodation, but there were no open positions available for a transfer. He chose to continue to work in the same spot. Let's see. After he returned from medical leave, Johnny met with the council person, Leslie Wessel. He told councilperson Wessel about the snake incident, informed her that Patterson had used the terms and at work. The next day, councilperson Wessel reported that conversation to town manager Evie Reset, who agreed to investigate. So there's a lot going on here.
A lot going on.
So the initiation seems to be that, verbal in the sense that he told the council person, his public works director knew about it. Written in that there's a workers' comp complaint where he alleges these things. Do you have any other notes on that?
No.
Okay. Scope of the issues. I think bullying comes to mind. If you have a policy against bullying, it may not be worded in such a way, but maybe horseplay.
Horseplay, yeah.
Yeah. Harassment, retaliation. You have anything else on that?
No.
Okay. So the investigator. I think potentially there could be an internal investigator here
I think so.
from another department, especially if they have, even the city clerk,
Sure.
as long
I think
as
so.
you're not related and you feel like you can be unbiased, I think it would be appropriate for an internal investigator. I don't know that there's a whole lot to investigate. He seems to kind of, as time goes on, he starts adding some things that maybe he had just let go in the past and has decided now I'm going to bring up these other comments that were made.
In terms of the racial
Yeah.
slurs, I would want to know, he said that those terms had been used at work. You definitely need to know how often. Was that just part of his everyday vocabulary, or was it a one-time incident, I mean, that needs to be pinned down.
Yeah, so it sounds like there might be an overarching theme of, just too much horseplay that's allowed to happen, which leads to people, lots of locker room talk, what we call unprofessionalism in the workplace. And we talked a little bit ago about a lot of times in the end, the investigative report will bear out maybe there's not a policy violation, but there's lots of problems with the supervisor and things going on in the department that are not professional and appropriate for work.
Right.
So the evidence, so what kind of documents would you collect?
Well, so I would want to know what's going on with how did Kenneth Patterson become the supervisor? So let's look at his personnel file. Let's see where he's been before. Was he new to the town? Did we do background check on him before we hired him? We may have to dig a little bit into his past if he's relatively new to the town. So I would want to know more about his history. Ask to see if there are witness statements that can be provided to you from the workers' comp file.
Mm-hmm.
You don't need his medical information, but if there are witness statements, I would ask to see those. Again, we always bring up the social media, but I think in this day and time, it's always potentially relevant. Training records, I would want to know what kind of training has been provided, since this workplace sounds like it's kind of not being run as it should be. So what specific training has been provided to supervisors and employees, separate and together? And then you've already mentioned policies and on workplace conduct. So we need to know. Hopefully there are some, but it sounds like we need some remedial training potentially if all of these things are substantiated.
All good things. I would look at his request for transfer.
Oh yeah, that was another thing.
To see what specifically that request was. Was it just to any open position? Was it to a specific position? Was he qualified for any open position? Was he qualified for something? Was he asking for a specific request? Was he offered other opportunities that
he chose to stay where he was?
Yeah.
And sometimes something that you may need to consider, are there other employees? Can you do a swap maybe? I mean, it sounds like you've got some issues to address in this workplace. You don't have to displace other employees, but sometimes that's an option. You at least need to consider moving people around if that helps to alleviate some of the continuing issues that are being complained about.
Well, and I would definitely want to talk to other employees in that department to find out this horseplay thing. I mean, it could very well be that this employee participated in the horseplay, but just didn't like this one incident. So sometimes you'll find
just the environment that they all work in? I mean, we've seen that so many times where everyone is complicit in the behavior, and it's it's okay till it's not okay, just like employees having personal relationships with one another. It's okay till it's not. What's going on here? Let's try to get that full picture.
Yeah. Okay. So let's see, who would we interview and what would we ask? Obviously, the complainant, that's what we were just talking about. The witnesses, what's the working environment like? Potentially, I would definitely interview the one council member that he spoke with, just to know what he or she knows, and why he chose to go to this particular council member.
I would like to know how long Johnny and Patterson have known each other, even though Patterson hasn't been maybe the supervisor for an extended period of time. were they coworkers before Patterson became? Does it say that? I don't remember.
No,
that
it
says
doesn't.
that.
So what's that history there?
Yeah, what is their history
Mhm.
with each other? I would want to know from Johnny why he's just reporting this now.
Mhm.
Why didn't he report it when the racial slurs were being used? Even though you say that your supervisor was present or was actually the one saying those things, why now?
Yeah.
What's prompted your request for some kind of action now? And what do you want? What is your expected or requested outcome as a result of this review of this complaint?
Okay. I've had people say, I just want an acknowledgement that what was said or done was a policy violation and I want an apology.
Yeah.
Now, obviously that doesn't happen all the time, but that does happen.
Right.
So a little bit of communication could go a long way. So an evaluation of whether there's harassment or bullying or discrimination, we know there is a race component. So if there is a policy violation, potentially, is it based on race? Did these things happen? Is there any reason to believe that these things only happened to Johnny because of his race?
Right.
Or was this the environment of the whole department and it happened to everybody without regard to their race? So I think those are, the equal opportunity jerk versus the jerk because of a particular reason.
I would ask Patterson, did he take any action with regard to this temporary employee and his, the snake? The temporary employee, is he an employee or is he through a temp agency? Are we going to address that with them? That there could be some fallout as a result of that.
Yeah, so. Was he gone the next day?
Right.
Yeah.
You didn't have him back.
They didn't think that was appropriate.
Right.
So. Okay, well, I think that kind of wraps up case study number 3, and that's our last one. And again, the workbook goes into, some sample investigative report, Garrity notice, some letters that sample letters that you can send, initial letter.
You'd said you were a big fan of those letters. I am too, because I think if you can communicate with the complaining party, you can't tell them everything, obviously, like if their discipline has been taken or whatever, but if you communicate with them, sometimes that goes a long way in their healing over whatever they've been going through.
Yeah. So different notifications, there's one for administrative leave, pending an investigation, closing letter. So, use that workbook to your benefit. We also internally have some other letters, or if you want us to review something that you've sent, we're happy to do that too. But so just to wrap this up, I hope you can use this workbook in the future if you have an opportunity where either you need to investigate something or if maybe you need to use it to show your manager or an elected official that, based on some of these things written in this workbook, I think it might be a better idea to hire an outside investigator. And, obviously you can call OMAG and we can help you work through that as well and help you decide whether it's something you can handle or whether it's something that you should really, get the help of someone outside, or whether we think, oh yeah, there's some potential litigation here. So I think you need to take it seriously and, get something done as soon as possible. So again, all of our information is on our website at www.omag.org. If you go under contacts in the legal department, you can find our phone numbers, emails, whatever you need. We have lots of policies on the website. Anything else that?
If they've got policies that they need help with, or maybe they don't have all the necessary policies, let us know. I can help with auditing your policies, and let's make sure that you've got everything in place that you need to have in place. Don't forget those bulletin board posters. We want to make sure those are up to date as well. So
Yeah.
we're here to help with any of those things that are needed in your for your employees in your workplace.